177 participants, Michael. You were popular. All right, let's see. Akhilesh, Akshay, Ami. Ami, you already got your Ravan 40. What are you doing here? You already got your EB1. You should be sleeping and having a good time.
I just wanted to know if there was going to be a movement in the EB1 dates.
Now you're
So
just being greedy. Now you're just being greedy.
now with so much uncertainty that with the H1B stamping and everything, it's just difficult to go home. So
That's true.
yeah.
Oh, I get that though. I get that. I have people in my network have been affected with this whole H1B. Is anybody stuck in India? Just that's a good question to ask. Or anybody know of their friend or somebody who got stuck in this whole H1B delay? Can you put it in the chat? Let's see. Hi Wujang, Viraj, Vipul, Vipin, Vinay, Udit, Tiru. Let's see. Oh, I know one. Oh, yes. That instills the fear of God in your heart when you're like, I don't want to take any chances. I'm going to stay. Um, that's just sad. Anyways, uh, let's see. Yeah, a friend of mine is stuck because of this delay. Updated appointment is 2027 now. Jeez. Okay. Let me start with a more hopeful sentiment than that. How many people are here for the first time? Let's see. Who's here for the first time? Arpita, welcome. Okay. Okay. I don't want to. You've joined the best number one session that you could have chosen. It's with somebody from the empire. I'm kidding. Michael Valverde. He is the former. Michael, I'm going to butcher this. You're the former associate director of field operations at USCIS. Did I get that right?
That's right. Yep.
Okay, awesome. And this is the second time Michael is here. I'm so glad that you are motivated to come back and talk to us more about your experience working with USCIS. So today's talk is more on the conversational side. Of course, Michael has some talking points, but I wanted to create a space where you can talk to somebody from inside USCIS for one goal and one goal only, to sanity check yourself. Because we're living in unprecedented times, that goes without saying. There are a lot of neuroses that I have caught myself um, engaging in, and most of them I have found to be ungrounded. So if you have any questions, which I hope you do, please keep them on lock. Michael will have from now till about 12:20, 12:25 ish, and soon after that we're going to launch into Q&A. And remember, no question is this is a dumb question, nothing. Like, if you have a question where you're like far-fetched, anxiety-ridden question where you're like, is this even possible? Michael is the person to talk to you about that. So no question is beyond asking. I just want you to remember that. This is a safe space, and you can ask those questions to alleviate your nerves so that you can go by in your life, living at it at a normal pace, as normal as things can be. So Michael, thank you again for being that voice of sanity for the community. We are going to take the good news with the bad news, but as long as it's going to give a reality check, that's what we need. And even if the reality is rough, we're going to take it. But we just want to know what is truth and what is just drama. So thank you again for speaking to us, and the floor is yours.
Awesome. Well, good morning, good afternoon, good evening, everyone. And I'll just echo, a lesson that I'm sure you've all learned in life. But if you have the question, then probably hundreds of other people have the same question. So feel free to ask it, and don't, regret not asking it. So that is the first thing I'll say. I'm going to try to share the screen and see if that works. And if it crashes like it did yesterday, I'll dial back in. So someone give me the thumbs up or not. If you see, me talking at you, I'm going to
Yep.
move that slide pretty quickly. Thank you.
Yep.
Um,
Yep. You're all good. Yep.
so move that to the next one, and more importantly, start slideshow. So it's a little bigger. There. Oh well. There it is. Awesome. So these are the things that I want to talk to you all about today.
Michael, just a heads up, the thing is still not on full screen, but that's okay. We can
No.
still see it. Folks, you can read it, right? Like what you see on the screen. Yep, we can read it. So even
Right.
if you don't go full screen, that's fine.
Okay. Yeah. Well, I mean, it's just an outline. Right. So talk a little bit about national interest waiver approval and denial rates and what I think it all means for you all. Upcoming changes in the rulemaking process, just in general. USCIS has been super busy, as you all know, with different policies, and they've announced that there are more to come. And we'll talk a little bit about at least what I foresee some of that being. And then, as someone already asked in the buildup, there's freezes, there's holds, both at USCIS and at the at the consulates for immigrant visa issuance, and what does that mean for visa bulletin movement? So I'll hit that, but maybe most importantly, then we'll get to the questions. And obviously we'll see where the conversation takes us. So again, thanks for tuning in. I hope this is helpful, and I look forward to the questions because I think that's always the most helpful piece. So first off, the national interest waiver approvals and denials. If you're able to access any data in this area, you'll know that petition approval rates have really gone down. They started the last calendar year where I think 3 out of 4, 2 out of 3, maybe that's probably better, around 65, 66% were getting approved, and the balance were not getting approved. And that's completely flipped. So if it's 2 out of 3 we're getting approved now, these days it's one out of 3 or even 1 out of 4 are getting approved. And that can be intimidating if you're in the midst of waiting for a decision, if you're starting to plan to file your petition. So I wanted to give that a little bit of context, talk a little bit about what that means, and certainly in terms of the immigration enforcement mindset of the current administration and everything else. So first, the context. If you look at the data over the past, 2021, 2022 to here, you'll know, and I think everyone knows, the number of I-140 petitions in the national interest waiver EB2 category has exploded, right? And there are probably 100 reasons for that, but it's gone up 10 times from where it was back in just 3 or 4 years ago to where it is now. It's showing signs of dipping back a little bit, but what that has meant, right, is you're all experiencing. If you're not using premium processing, it's taking a heck of a long time to get those decisions, and at the same time, because decisions have a delay from applications, you're starting to see those higher denial rates, like I just spoke about. So the context that I wanted to provide, though, is that the aggregate number of petitions having grown so much means that the aggregate number of approvals has stayed pretty steady and maybe even has crept up, while the aggregate number of denials has grown. There are a number of different theories out there. If you look at the data, and one piece of data that I don't think is apparent to the community, maybe it is, you all seem to know everything anyhow, is that the only a few countries make up some large percentage of the growth, right? There have always been a very strong filing rate from India, but other countries have crept up, and the percentage of the top 5 or whatever has really shown that a certain handful of countries have made the difference between where it was 2 or 3 years ago and where it is now. And it's my guess, although I haven't seen this data, that a good portion of the denials come from some of those new countries. So, if you're from one of those countries, you're probably seeing a lot of your people that are in your network and your network of citizenship seeing denials. If you're not, my guess is, and the folks on the call can shake their heads or nod their heads, the anecdotal evidence that you see friends and folks in your network who are not from some of the new countries who are filing, and I'm purposely not naming them, but I think everyone probably knows which ones they are not seeing a big change except for just the slowing of the processing. Where there has been a big change, and what I wanted to talk about a little bit before I move on to the next topic, is, how does it relate? How does petition approval, and then following on, how does adjustment of status approval relate to the new, I guess it's not new anymore, but the Trump administration and their policy, their platform of stricter immigration regulation, immigration enforcement, and all of that, right? Where is the NIW policy that has driven some of these denials? And, the first answer to that question is there have been no apparent policy changes in the national interest waiver area, not any memos or not any decisions that have come out to drive policy change. So, there's a strong argument to say that the denials represent people who were taking a gamble on some of the relaxed policies and procedures that were initiated in the late years of the Biden administration. Now they're coming up to get their adjudications, right? So a lot of the denials that we're seeing were filed in the fall of 24, the winter of 25. We're seeing that the agency's adjudication standards did not move as much as those policies suggested. So, if you're in the process and you thought you were eligible, you had a strong resume 2 or 3 years ago, I guess the bottom line for me is you likely still have a strong resume. There's no doubt that this administration is adjudicating things closer to the line. They're giving less deference to gray area decisions. They're looking harder at, some of the evidence. But if your resume supports approval, I think you're still in running to get those approvals. It's the gray area ones, and certainly some of the ones that relied on some of the late Biden era policy, relaxing policies that are seeing the denials. So, I guess what that means is, except for the extreme length that it's taking petitions right now, and someone, I don't even think they were joking, was comparing national interest waiver decision timelines to EB-1A timelines, and said it's really switched, and the EB-1A is a much faster route these days, just in terms of the agency, not even talking about the visa bulletin. I think it's a reflection of that. But that, and the big but and the big asterisk here is to say there is certainly an impact of this administration's attitude towards adjudicating these petitions, right? Despite the fact that there's no apparent public policy shift, there's been a lot of denials, and there's no doubt that the agency is looking harder at the evidence and probing more deeply. So, what does that mean? Depending on where you are in the process, it has very different impact, right? So many people aren't able to file concurrently because of visa bulletin waits. But if you do file concurrently and you have that 485 pending and your I-140 is denied, then your 485 is going to be denied. And that's happened a lot for countries who aren't, like India, or that's happened a lot for rest of the world countries. And that's had statistically a bump in 485 denial percentages. So it looks like the agency is denying more I-485s for EB2, based on EB2 cases. But in reality, that's just a reflection of the fact that they're denying a heck of a lot of petitions from rest of the world. If you pull that data out of the data set, you'll see that if you get an I-140 approved and you get your priority date becomes current, you have a super high chance of getting your green card or getting your immigrant visa. USCIS continues to approve in the high 90 percentages of I-140 based 485s. So, that tells me, as before, the real hurdle, the real obstacle is getting through the I-140 stage. And again, there's a lot of data that you can put in ways that will make you think that it's harder than ever. And there's a little truth to that. But as a matter of fact, the aggregate number of approvals is still high. And that that's true because of the visa bulletin movements has been a little bit, but not massive, right? If the USCIS starts denying petitions, they start worrying about their ability to use immigrant visas, and those numbers, those dates will start moving forward. And like I said, there's been some movement, as there always is, usually towards the start of the year. And then, they're sort of assessing right now how usage will look and how approval rates and how denial rates go and the impact of the freeze and the holds. And we'll get to that in a minute. But that's, that to me is an indicator that they continue to see high aggregate numbers of approvals, even if the rates of approval is low, right? You all probably get the math, so I won't over explain, but the more that's filed makes room for both a higher number of denials and a higher number of approvals in the aggregate, and that supports the usage of immigrant visa numbers. So that's, anyway, my perspective on what you see. The bottom line is the petition adjudication time takes much longer because there's a lot more petitions in the system and the agency hasn't grown its resource to adjudicate them. But that also means a lot of approvals, a lot of denials. And when you look sort of deeper into it, those cases that previously have been approved continue to be approved. Those cases that weren't up to the standards of the agency are getting denied as they were before. And the difference, the Trump administration impact, I think, is that they're taking a real hard look at your evidence. When you find yourself in the gray area, more RFEs, more noids first, and a harder time convincing them of the righteousness of your petition if you find yourself in that space. So that's the first bullet. Second bullet on the screen, really the second and third are together. So USCIS, obviously is in charge of a lot of the immigration adjudications, and thus they're in charge of the regulations that support the process. As you know, if you've been, digging into this or trying to do your own thing, there are other ways that USCIS policy is impacted, case law and decisions and BIA decisions. And one thing I get asked about probably on, I won't say daily because that's an exaggeration, but on a pretty regular basis is USCIS has updated its list of proposed rules that they're going to do in the spring of 26. So, soon-ish, indicating that they're going to do a rule on employment-based petitions, right? And it doesn't say much more than that in the blurb. But they're going to look hard at EB1s and EB2s. I would expect less on EB3s. So on that rule in particular, again, I get asked that about daily. Up until really last week, I would have said that rule is on the back burner at the agency. I had heard through some of my channels that it wasn't a priority rulemaking, and I would have advised people who are in this space to be more to expect first an OPT rule or CPT OPT rule or an EAD rule, and then maybe later in the year or sometime down the line, this I-140 employment-based petitions rule. Something happened last week, though, that I think might change that and might put this rule back in the priority category. And that is, there was a district court decision for one case out of Nebraska that eliminated the final merit, or seemed to say that the final merits determination was extra statutory and thus improper for USCIS to use. Now, that's something that a lot of people have thought for a long time, and this court recognized it. And in this case, they said, I forget the facts. The person was found eligible in either 3 or 5 of the criteria, but not eligible on the final merits review. And the court said, well, they are eligible, and it sent it back to the agency for approval, saying the final merits process was not properly implemented. The way to properly implement it, right, is to put it in through the federal rulemaking process. to give the public a chance to comment and say, yes, you're getting it right, or here's why it's not correct, and then finalize the regulation after that process. So that's why I'm saying, if I had thought, before last week, the EB petition rule was on the back burner, it's likely on, back in a priority with the agency. What do I expect in that rule? Again, before even this administration, this rule had been bouncing around, and it was a sort of a non-controversial rule that was updating the regulations, taking out some things that don't make sense, adding in some of the things. So this final merits review and the dissents, I'm just going to say it wrong, but the NIW process would have been in this rule, and it would have just made it more transparent and made the way that the agency has been adjudicating consistent with the regulations. I expect that they're going to turn to this rule again and try and do the same thing. This administration has a very immigration enforcement attitude, so I wonder if the rules that will come out will take the final merits review or the national importance consideration for NIW and push it even further and give the agency much more discretion to make those decisions. Yes, you're objectively eligible under the criteria, but we find that your employment will harm U.S. workers, right? That's been the consistent line that this administration has spoken when they look towards immigration. Is it hurting or helping U.S. workers? And so I would expect that they would put that in the proposed rules. Now, I don't know if it's good news, but the good news is that this is a proposed rule. So they would have to say, here's what the rules are going to be. They would give people 60, 90 days to make comments on it. And then they would have to address all the comments and finalize the rules. So we're not expecting that this rule will become effective for petitions, on February 2nd or March 2nd or April 2nd, but probably further down into the summer months in the U.S. till they get the rule finalized. And even then, when a final rule comes out, the agency trains its staff on the terms of it and implements it usually 60 days or so after the final rule is published. And it'll say that if anyone has ever looked at these rules. Hopefully not. Hopefully you're doing better things in your life. But they normally have an effective date that, they publish it on X date and it's effective 30, 60, 90 days after that. So I would expect that as well. I'm happy to talk about that. And then just to get through the three bullets I wanted to hit, and then I'll stop sharing my screen so I can feel like I'm not just talking at my laptop. What do the current policies, the immigrant visa freeze at the consulates and at USCIS? There's 39 countries whose adjudications are on hold right now. So, what does it mean for visa bulletin movement? That's another question I've gotten a lot, right? If you're in that country or if you're in that list of countries or you're not, obviously the impacts are different, right? If you're in those countries, you're stalled. I encourage you to keep working through the process. If you're thinking about filing, you should file. If you've got an interview scheduled, go to that interview. The policies both of USCIS and of the State Department seem to be, although we'll watch as time moves on, that they're going to continue to do all their work until and up to the point of making decisions, either issuing that visa or approving or denying that petition. So and if you're in the U.S. and you've got an approved petition, then there's nothing to stop you from filing for adjustment of status. So my advice for anyone caught in this is to continue the process. But what does it mean for the visa bulletin? Real quickly, folks on here might know that in terms of employment-based visa usage, USCIS adjustment of status uses about 85%, some years 90%, of all the employment-based visas, and consular process visas are about 10 to 15%, right? So the majority of cases that use up employment-based visas and therefore move the numbers forward eventually are domestic. They're here in the U.S. So the immigrant visa freeze from abroad likely won't impact a lot of changes in the visa bulletin. Period. I guess I'll say with or maybe comma with certain provisions or exceptions. I guess. The real impact, though, is the hold in the United States. And obviously, both of these, the longer it goes, the bigger the impact. For the immigrant visa, I think the exception to what I just said is EB3. A lot of EB3 cases are still coming from abroad. So I wonder, those numbers rarely have moved lately. I wonder if that will result in certain movements because not only in certain sectors, healthcare and others, are countries who are in the freeze and in the holds well represented in the EB3 category. So all of a sudden, a lot of visa usage is on hold. So that might move those numbers forward and might also free up some numbers. And this is now but for all categories. The longer the visa freeze is in effect and the longer the hold at USCIS is in effect, the agencies will be tempted to start allocating more visas beyond the country limits. That's not something I would expect to see in February or March or April or May. But as we get to the last quarter of the U.S. government's fiscal year, June, July, August, July, August, and September, I should say, there'll be more pressure if these holds are in place or they're in place a long time to utilize all the visa bulletins, all the visa numbers, and the pressure will grow to enable countries to use more numbers than they're normally allotted. So that's not going to happen, like I said, in the spring or even early summer, but look for it in the July timeframe. And again, that's when I think the visa bulletin impacts will occur. Obviously, if maybe it's not obvious, if the State Department and USCIS end their freezes and their holds next week, then there's probably a minimal impact. The longer they go, the more likely the impact are. I think we'll see EB3 numbers probably move. And I think in the summer, we might see some of the non-rest of the world numbers move a little bit more than you'd think they'd move because what I said earlier, the need to use all visa numbers will enable the people who oversee this to go beyond the normal per country limits. I'm going to stop there. I'm going to stop sharing and see if that worked. Go to questions.
Awesome. Michael, before we take questions, I have 3 clarifying questions given the position that you held in USCIS. The first thing is, you said that countries who are banned, it affects the consular processing, but what about if we have residents or citizens of those countries in the US? For example, let's say Nigeria. And they are in the US right now on a legal status. Now, does that mean they're exempt from that ban, or what's happening for them?
So, great. There's a list of 75 countries that are really just banned from getting an immigrant visa. So everything up to that at consulates. If they're in the United States and they have adjustment of status pending, then USCIS will adjudicate those adjustment of status applications. You'll get your approval, you'll get your green card, and off you go with the next part as the exception, right? Then USCIS has a different list of 39 countries where they're not doing any decision making on any cases, employment authorization, petitions, adjustment, or even citizenship for folks from those 39 countries. So, it all depends on where you're from and where you're at. So if you're in the United States and you're not on the list of 39, then you are continuing your immigration journey as normal up until the point that USCIS changes its policies, which I thought they would do immediately, but they haven't done yet. But if you're on the 39, if you are from either a national or a citizen, if you're born or you have a passport from one of the 39 countries, then you're probably stuck. If you get an approval, you should celebrate. You should go out and have dinner with appetizers and dessert, because that means the agency made a mistake and you got something that they weren't intending for you to get.
Got it. Add some extra avocado in there too. I'm kidding. That's a very millennial joke. Second is, the average tenure of a USCIS officer is pretty long, right? Like there's not a lot of turnover in a USCIS officer's life in the US. I mean, in the agency, you would say.
Yeah, I would say this way. So the agency is just like I guess any agency, it has different offices to it,
Right.
and different grades, right? And so as you are an officer in your tenure, you grow through the grades, which means you get paid more, and you get to the top of the pay grade, and then you stay there, or you get a promotion to a non-officer job or whatever. And those individuals at the top have a lengthy career sort of by definition, and they're relied on
Got it.
premium processing and other things. What we saw at the start of the Trump administration, and one reason I'm talking to you here, is they made the early retirement rules very generous, right? And so I took advantage of it. I won't lie. I thought I'd be working for the agency maybe another 10 years. But I took advantage of it. But those rules were only for someone who had a lot of time in the agency. So the agency has lost a lot of its experience at the officer level included. And so right now, I would say there are a bunch of new officers who were hired at the end of the Biden administration with very low experience levels, and there are a bunch of senior officers. The middle level is a little empty. So
Got it.
I think that's, and why this matters. So great question is that if you have a premium case, you get officers who know what they're doing, and you're more likely to get a decision that makes sense, because those people are put on premium because it's a really important workload for the agency. If you're not on premium, the chances that the officers who are doing your case have a less level of experience are higher than they were before. And so, normally I would have said, sorry, long answer to a short question. Normally I would have said the only difference between premium and non-premium is time. You'll get the same RFE, you'll get the same approval, you'll get the same denial. The fact that premium has so much of a higher approval rate really meant that people didn't want to pay that money unless they were confident that they had a really strong package. These days, that's still probably true, but also I think there's a qualitative difference between who's looking at your case right now between premium and non-premium. And if you have the money, it might be worth considering premium, because you might have a better chance of someone who understand your petition, decide not to ask an RFE for reasons that are unnecessary, decide not to go down the NOID route because they don't understand your package, and go to that approval. Anyway, so that's
Yeah.
a long answer to a short question.
The reason why I'm asking is because this is a thought process that many of us have. And I know that for a fact because I too had this thought process that when a new administration comes, somehow there is a overnight shift in the USCIS officers. And somehow they overnight become these racist people who are hell bent in denying us. When we don't realize this, it's the same adjudicating officers with a new playbook, possibly. So that's what I wanted people to know, that it's not a Hufflepuff to a slithering house change. It's the same officers who are looking at your case. So it's just that they may be dealt with a playbook that has more stricter adjudication, but in terms of their attitudinal shifts, it does not really oscillate with who's in the White House. Would you say that's a fair assessment?
Yeah, no, I do. I think it's all about the policy changes. The officers are generally the same. You if you've been paying attention to USCIS hiring, which I guess people probably aren't, you'll see that they do advertise now with a very pro-Trump. I don't know how to say this better, but they're trying to hire officers who support the current policies. But other than those new hires, the same people were there on January 20th that were there on January 19th, and their decisions, the way they evaluate the evidence isn't changing until the policies change to tell them, yes, that used to be good enough and now it's not good enough or whatever. And on a good day, most of that is transparent and public.
Got it. And the final question I want to ask you before I give the floor to folks is your office was responsible for adjudicating the I-485 stage, right? Like you had officers that you oversaw who was doing this step. So I wanted to ask this question, that is it within the means of an I-485 officer, if they are suspicious of your case with this heightened scrutiny that's going on, that they can reopen your I-140 case and then revoke it? Is there a non-zero possibility?
Correct. Yeah, no, they have the the full authority to go back and to reassess the merits of the petition. In practice, and you've seen it, I'm sure you have examples in Reddit and maybe even on this call of folks who've shown up with an I-140 approval and then had a long wait, and it's resulted in a notice of intent to revoke the petition because of something the officer thought was wrong. But that's really rare. The officer, the petitions have a really deep look, hard look. The evidence is kicked around and scrutinized at the petition stage. At the adjustment stage, that is one thing that officers look at, but they are shifting from, is the company the right company and have they jumped through all the hoops? Does the person have all the qualifications, to the admissibility of the person? So they're really taking a harder look at all of the things that, it's a criminal issue these days. Is there a social media issue or whatever? That shifts at the 485 stage. And, the data show, like I said a minute ago, for the most part, if you get your approval petitioned, you have, percentages are really high that the adjustment gets.
Higher likelihood. Yeah. Awesome. Folks, it's 12:38. I'm going to have, Michael, is it okay if you stay till 1:08?
Sure.
Okay, great. Awesome. Folks, the house rules, one question per person, please. One, not 1A, not 1B, just one question per person. We're going to go down the list and we're going to take as many questions as possible. Arun, go for it.
Hey, hi. Thanks, Michael. This is Arun. So I work with a bank in a regulatory space. Wanted to check, for a recommendation letter that we have to get, does it carry more weight if we get the letter from a regulatory examiner from FRB or OCC compared to a standard industry expert letter?
Oh, yeah. I mean, obviously, it all depends on context. But yes, I think so. Experts in the field who are working, I hope I'm answering the question with the concepts that you're asking about. But if they're in the field and they're in the field in a sort of compliance way, and they say what you've done is, they opine on what you've done, absolutely, it's a really powerful way of showing qualifications.
I'm sorry, I'm getting some feedback.
So you can keep mute if you're not speaking.
No, it's not you, it's somebody else. I hope that answered your question, folks, but I do want to clarify, this is not an EB1A session. This is understanding how USCIS works under regulation changes session. So if you have EB1A sessions, come for an EB1A session, but Michael is more responsible for giving us the inside view of, okay, things are changing in USCIS. What does this mean? So if you can keep your questions focused on that, that'd be wonderful. We can get more deeper insights from Michael in that regard. So I want to put that caveat in there. Krishnan Sharma.
Yeah, thank you, Michael. Thank you for the session. I have a specific question about the sustained history, both for EB1A and for INIW. So my question is that, does USA look for how much sustained history you have in a particular category, and is there any time limit which they decide when they look for the particular category?
I think this is, again, is Michael here? I don't know, where did Michael go?
I think he's on mute.
Yeah, somehow I got on mute. Sorry about that.
Oh, yeah. I think Krishnan's question is more on the sustained acclaim side of the story, Michael. So if you can comment on that.
Yeah, no, definitely. I mean, if the question it boils down to, is there a specific time frame that, if it's, well, I'll say it this way, time frame sustained, it is important, right? And you get, everything's on a spectrum, right? So if it's, you just started to show your impact and the oldest thing in the record is 7 months old, that's not going to work for you as well as something that's 17 months old or 27 months old. It's not impossible. The context is everything, but it works for you the longer credible pieces of evidence showing that you're as impactful, as effective, your endeavor is all of that. I feel like I'm saying something that's self-evident, but the longer the better.
Yeah.
There's no if it's 90 days, it's not good enough, but if it's 90 days, it better be really good. It better be worldwide.
Yeah. This is a question that Evan Law, he's a former USCIS officer, he used to be an AAO officer. And again, this, I don't know, there are hundreds of officers, we're talking about one. But he said that he went as far back as 3 years, but that's not to say that that is the timeline that you adhere to. But yeah, Michael is right, is as far back as you can go. But no, the sprint mindset of like
Yeah.
chugging everything in 1 year is probably not going to work, especially now.
Yeah, no, I mean, and I would say, I've had a client who wanted to say he had 2 years, but it was really, something happened in December and he was now in May, right? And that's, like 6 months. And so
Yeah.
the agency will see that. And, the advice that I would give, and, self-plug that if you come to me, you'll hear this, is exactly what you said, sprint, I guess, if you can justify it and your accomplishments are incredible, but it might be better for your time and your money if your life and your immigration status can afford it, to spend that time building your record, building your resume, and coming back when you do have 28, 36 months of evidence before you. Yeah, I think Evan is probably not wrong at all. That's a healthy timeline.
Yep.
But Michael, expert question. So
Um,
does the USS look for the sustained history across all the categories, or like a main primary category such as your profile, how much your salary, sustainability in the
Oh,
historical
yeah.
past? Yeah.
It is, yeah, no, great question. Not across every category, but the sort of the sum of all the things. So if you didn't start being on, reviewing the work of others or whatever your example is until last year, that's fine, as long as you have a handful of other things that do go back further, if that's what I get.
right.
Okay. Thanks
Yep.
for the clarification.
Yeah.
Yeah.
Yeah. So Janya,
Yeah, so for what would be the membership that would consider for membership criteria like
folks, I'm gonna pause. Saujanya, folks, I want to remind you, this is not an EB1 session. This is a USCIS operations session. So please keep your questions to that, because Michael Valverde did not oversee EB1 cases. So he is giving you overall assessments, and I appreciate that, Michael. But Michael is not the person you should be asking EB1A specific questions. So if you have a USCIS question and regulations question, please go ahead.
okay.
All
I'm
right.
good.
Okay, thanks. Kaushal.
Hey, Michael, thanks for doing this. So quick question with your comment about the staffing and the RFE. So I have an approved employment-based I-140. I have an NIW application that's been in the queue since February 2025. Do you see any benefits outside of just getting the decision sooner of doing premium processing versus not? My priority date is not a concern at this point. It's
Right.
just far enough out.
Yeah. I mean, I guess the point I was trying to make is that right now the agency is experiencing the agency has only a certain quantity of well experienced officers, and the ones who are best experienced are doing premium processing, because it's really important to the agency to keep that up and not return the money. The data starting to show, some quantifiable differences in case outcomes between premium and non-premium. Generally, though, it's about RFE issuances. I think the bottom line and decisions are probably pretty similar still. So I'm not at the point of saying, abandon hope if you're not premium, because that's an expensive thing and that's a commitment. But it's starting to have an impact. So, again, it's, if you feel really strongly about your case and your merits, and it's not a gray area, it's not an iffy one, then the advice that I generally have been giving folks is it's not a big risk. It's not to risk staged where you have to do premium to get the right decision. They're both approving. You have maybe a higher chance of RFEs, which is something that used to not be true, but I think is probably true now.
Right. Fair. I think that helps. Thank you very much.
Yeah.
Krupal. Krupal. we're gonna come back to Krupal. Sumi Sola Alare.
Hi, Michael. Thank you for doing this. So I do have a question. Do you have an idea what to expect? Because I think I did hear sometimes or read somewhere that the USCIS was reviewing benefits that were approved after January 2021. So who would you say like benefits regarding, would it be green card or like OPT? Like what should that be expectation look like?
Yeah, no, that's a great question. I don't, the policy memoranda that they issued was super broad, right? And again, it was about if you're from a certain country, they're going to review benefits. The folks that I know who are still at the agency, I think were initially challenged to say which benefits they think they should review first. So it will be sort of prioritized. I think the media has shown that the agency is really interested in reviewing refugee admissions. I think before long there'll be litigation about that, especially if let's say you had a green card and now you file for your citizenship and it's not moving forward because of this review. I think sooner or later people will be able to show harm. So I guess a lot of words for me to say. I'm not sure what form it will take. The memorandum also says, I think what's most instructive about it is it's going to look to see, to make sure decisions were made not to grant benefits to people who are on the terrorist database, not to grant decisions to people who are otherwise, counterintelligence database or spies and who are criminals. And then the final one is identity issues. I know from just being there for years, the first three, the criminal and terrorist piece, is something that, despite whoever is the president, the agency took very seriously, right? If there's a list of people who another government agency calls terrorists, then they're going to look at it. They're going to have a real hard time approving a benefit for that person, right? That's not a Donald Trump thing or a Joe Biden thing. That's a forever thing. So I think the issue will come around in terms of your identity documentations. And so I've been advising clients to, if you're in that category and you expect your decision might be reviewed, start getting, if it's a birth record from a church or a birth record from a hospital, and not rely on the passport that your country gave you, because USCIS has said they don't necessarily believe that I just pick one of the countries on the list. The Cuban authorities are producing records that are verifiable. So they might come back, ask you about that.
Got it. Chandra Suma Miriala.
Hi, good afternoon. I have a question more about, it's not EB1A specific, but how does the agency look at, like if you had a previous EB1A denial and you have an NIW approved and you want to go forward with either an EB1A or an EB1B, how does the agency look at your case? What are the things that I should be paying attention and not be in the gray area? At least try not to be in the gray area where I might have a greater chance for denial again.
Yep.
So
No.
what are the things I should pay attention to?
So super question, another one I get asked a lot. They absolutely do, know about, and it's all in your files, past denials. So they'll be able to see that. They'll be able to see the reasons. So that's the first thing. The second thing is they have to adjudicate your case based on the arguments you make on your new case, right? So unless you just file the exact same petition with the exact same wording over again, which might allow them to deny without too much thought, they won't be influenced by the prior denial. Or maybe said differently, the prior denial, they can't refer to it in a future denial. They have to deny you if they're going to deny you or issue you a request for evidence based on the evidence that you submit. So what that means is, at best, that prior denial works for you as a roadmap of maybe what you got wrong and what you can perfect in the next application. So you can even say, I was denied because of my failure to show, whatever criteria, and now you're going to knock it out the park. So they'll see the difference. So, I guess the summary of the answer is they'll absolutely look at the old denial, They have to adjudicate you based on the new arguments you make. And the old denial is really a helpful roadmap sometimes to show you how to improve on your next petition.
Right.
Thank you.
Folks, before we move on to the next question, how many folks are on like F1 visa or OPT? Can I see with a show of hands? You can do this. This maybe. Okay. Okay. All right. I'm going to put a link to an attorney's take on your stickability of whatever decisions you take in your immigration on your immigration records. So, Michael, this is a article written by immigration attorney Andre Matias, and the reason I'm saying this is because there's an appetite because U.S. immigration is so painful. It's like doing crunches that we want the six pack, but we don't want to do the like hit exercises. So we all want to get out of that pain. So we rush into immigration decisions, but those immigration decisions always stay on your record. So Andre Matias, in that post, he goes on to say that if you're an F1 and if you apply for your EB1 and it gets denied, and you try to go out of the country and come back, then the officer can see that you showed immigrant intent, even if it was denied.
Yep.
So we need to be extremely careful when we make these decisions because they all stick. And
Yep.
this is not an express way to getting out of US immigration pain. So be very calibrated in the decisions that you take.
It's a great point. Yep.
Yeah. All right. Krupal, I see that you're back. You can ask your question.
Can you hear me now?
Yes.
Thank you. Thank you, Michael. Thank you, Aditi. So my question is regarding I-485 filing timing, but it's linked with the EB2, EB1. So in the case of already having approved EB2, which is a priority, like that priority is current. So in the current situation, shall we submit I-485 along with the I-144 EB1, or shall we wait for the approval of the EB1 when we have a lot of uncertainty of the EB1 approval?
Yeah, I was having trouble tracking. I mean, does the question boil down to do you want to wait for the if you have a priority date that's available and you have an I-140 pending, do you want to wait or do you want to file them both together?
I think it's it's about concurrent I-140 and I-485.
Yes.
Yeah. I mean, I'm a proponent of concurrent because it gets you that EAD if that's helpful for you. Gets you the I-131 sometimes, although these days that's become less of a sure thing. But if that's not necessary for you, if you have employment otherwise and you're not planning to change it, then then not necessary, right? And then you can save that resource. But if you're sure of your I-140, it saves you time. It saves you a ton of time to file concurrently.
Yeah. Santosh.
Hi, Michael. This is Pranita. I actually wanted to ask you, like you had mentioned about the last week update about the judge, the criteria that if you meet the three criteria and the final merits thing. So, did you say that it will be effective from summer, or it can be taken back again, or there can be some more policy changes? And
Yeah. Okay. Yep. So what?
My question is not complete. Sorry. So if they think that we are still harming the job market, right? So I am from the healthcare area. So my question was like, if I'm not harming the job area, will I still qualify based on three criteria?
Sure. So I think there's a lot to that question. So what, for those of you, again, you're living your lives, so you're not thinking about this stuff 100% of the time, maybe just 75% of the time. There was a court decision that came out on an EB1 case where they said the final merits was inappropriate. The agency didn't have that authority to do final merits. And for that one case, they sent it back to change the denial into an approval. That's only on one case, and I'm sure attorneys will take that under consideration and maybe try to push that. But in the meantime, I'm pretty sure the agency is working on regulations that will put the final merits or the or in the national interest context, the national importance into the regulations and make them effective. And they might make them effective even more broadly than they are now. And I think this is your question. And I said earlier about the administration's laser focus on the impact of these visa issuances on the experience and wages for American workers. That's all perspective, right? Those rules have not been implemented. I would expect we would see the proposals sometime in early spring, maybe late winter, and they would not be finalized at the earliest then until the summer timeframe. So right now, that is all perspective, and none of it is exactly known how exactly the policies will be. So, that's an argument for getting it while you can. If you're eligible now, make your case now before those rules change and get more difficult. I think in the healthcare industry, it's always going to be pretty difficult to argue that there isn't a genuine need, but that, why worry about making that argument if you can not have to worry about it by applying now? Thank you.
Okay.
Thank you.
There are some questions in the chat, but I want to go through the people who have raised their hands first. Lokesh.
Good afternoon, Michael. Yeah, my question was exactly what you're describing. So it's the same, like USA has mentioned, I think the timeline was, they mentioned that there will be some policy changes for employment-based visas. And like 2 or 3 days after that, there was this court decision on final merits. So I was just going to ask, like, what do you think? Will they consider this court decision and make changes to the policy again, and to include this final merits too in their policy document?
I think so, or something even broader than it. But yes, I think there'll be the final merits or the national importance, and the national interest waiver will be codified, and that'll be helpful because then we'll know what folks have to show. But I think this administration has shown they don't ease back on the rules; they only make the rules higher standards and more difficult for people to make. So
if I'm understanding it correctly, Michael, you're saying that there is a reverse effect of this court case, that USCIS may just want to double down on final merit.
Yeah, I mean, I think they were relying on the fact that they had final merits authority and were, my guess, so again, the long story is this particular rule has been in draft form for more than a year, right? Dating beyond this current administration, and it was going to put a lot of things into the regulations that were not in the regulations, just for transparency's sake. So I think that's probably going to go ahead, and part of that is the final merits piece, and Kazari in that decision. But this administration has also shown its policy preference to make things harder and to give more deference or more discretion to decision makers on areas like how does it affect the domestic workforce. So I wonder, yes, this is a great decision for that person. Right now, before this regulation comes out, lawyers will probably be able to make it into a bigger thing, or maybe in that district go back and ask for some denials to be reconsidered. So probably right now there's this opportunity. But I think going forward, this is me. I think I said the other day, pouring some cold water. It's probably short-lived because the agency is probably now really motivated to get this rule out and to get back, at least to get back to where they were, if not make the rules a little more strict.
Got it. But the off chance of final merits being completely eradicated, that's not.
It's not, it's not zero, right? Because there's at least one judge in a district court that said the agency does not have authority to do that. And what the rulemaking process is where the agency says, yes, we have authority and here's what we're going to do. So lawyers will probably go back and take that decision and look at it very closely and say, does the law even allow the agency to do that, even with notice and comment, even with a proposed rule? So there'll be an argument there, maybe litigation. And so, yes, that's a lot of negatives. There is a non-zero chance that maybe this policy this court decision is the start of the end for final merits. A lot of lawyering has to occur both on the agency side and the contesting agency action side before we'll know.
But for people who are looking into EB1 in the next 1 to 2 years, would you say just put your head down and act as if everything is the same?
I think right now nothing's changed except for that one case. And
Got it.
as things move forward, then we'll see what changes there are. The other thing I say that we just completed the first year of the 4-year administration, and we don't know who the next president will be. But we know that things are probably not going to get easier or more simplified over the next 3 years. So now is as good as it's going to be. I think in terms of showing your eligibility, it's only going to get more difficult. The standards are only going to get higher if you're to believe this administration's stances on immigration. I think they showed they're sincere. So the other piece is if you can and you're able to get it while you can now, because it's only going to get harder, at least for the next 36 months.
Got it. Aren't you glad that you came to this session? All right. Avinash, we're going to go to 108. So as many questions as we can till then. Avinash Madasu.
Hi, Michael. So my question is more about EB1 ROW spillover to backlog countries. So I saw the inventory for ROW EB1, and up until last, I think like financial 2025, we had around like 28,000 EB1 ROWs, I-485s. So my question has really two parts. One is, do we expect like the same number of applications every year, or if we don't see the same demand, like when will USCIS start using those numbers? Will it be the current financial year, or will it spill over to the next financial year?
That's a great question. And if I had a definite answer, then I probably wouldn't be on this webinar. I'd be wealthy. I'm be on my yacht. So please take that for granted, please take that into account given the answer. But yeah, I mean, I think if anything, the agency has seen over the years the growth in the I-140 demand, right? Sometimes it stalls a little bit, but continuously, if you look back, it's grown. And I don't know that there's anything that that we've seen to suggest it's going to slow down for an extended period. This administration has had, as I've said, policies that a lot of people are reconsidering if they want to come here or whatever, but I think the numbers show there's still high demand. So that's the first piece. I wouldn't expect that the demand will long-term falter unless Congress changes the number of employment-based visas available. That pressure will still be there. What we have seen though is like I started the session with, despite the demand growing, the number of denials has also grown, and the number of approvals has flatlined or grown a little bit. So what the agency watches is that, petition approvals, and then beyond that, obviously 485 approvals are the real gold standard of saying at what rate is the agency approving a 485, and is that consistent with visa usage. In the last few years, the agency has been approving it at a pretty rapid rate. So anyway, long way to say, I don't expect the demand side to impact visa number usage and visa availability too much. If it does though, and if the falling approval rates start, or the pauses and the holds start to give the agency concern, again, we'll see the movement occur late summer or early next year. The start of the fiscal year numbers will move more than one might expect. So that's the timing of when you'd see the impact of some of the trends that you're watching.
Got it. I'm going to take a pause and ask a question that's in the chat, Michael, if that's okay. This is from Temi Dire. He says, or she says, does policy memorandum regarding the hold and review of USCIS benefit applications from high-risk countries impact EB2 NRW petitions given it's under national interest? Furthermore, does this policy affect EB1A applications differently since it's not necessarily national interest?
So I think so I'll answer the question directly. I don't think the policy memo impacts the petition approval. If they change the rules the way that I was talking about 5 minutes ago, I think it will. But right now, no. But I think it will. The policy memo will impact at the bottom line, right? The bottom line is not getting your petition approved. The bottom line is getting your green card. And I think that's where at the I-485 stage, they will start to look at issues like identity and other things. So not necessarily about the national interest of you working in the economy, but the agency's ability to know who you are. And right now they have a presumption that they aren't sure who you are if you're from one of the 39 countries. So I think that's when you'll get hit with the RFE that says, show us why it's in the national interest for you to get your green card, and you maybe get hit for a request for evidence about identity documentation.
Got it. All right. Final question, Shiv G. Or
Hey,
did Shiv already ask? Oh no, you're
no,
gonna
I
ask now.
haven't asked yet. Hey, Michael.
All right, Shiv.
Hey, Michael, you had mentioned about staff shortages at the USCIS, especially at the senior level. Has that driven the adoption of AI tools within the agency, whether it's to assess petitions or detect if the petitioner has used AI, or do they care about, if someone has used AI and they'll be like, no, this is not allowed, reject?
Yeah. My experience is not yet. I'll give a quick answer. The agency was not using AI in terms of petition evaluation when I was last at the agency before I retired. The agency is, if you believe it, they have to list the ways that they use AI on a DHS website, and there's no petition adjudication use case on that list. And then the third thing that I'd say is right now, given the policies of the agency and the department, which are all about detecting fraud and fighting against fraud and obviously terrorism and criminals, if there is going to be an AI investment, I think that's where it's going. So less about evaluating your petition or determining that it was written by a human or AI, and more about ensuring that they know all of the criminal issues, more about evaluating social media if that's what they care about, and that sort of thing. Maybe that's a short answer, I don't know, but the officers don't have tools right now to do petition evaluation through AI.
But do they care if we use AI for our
I don't think
petitions?
so. I mean, they are trained to look at evidence. Whoever pushes the evidence up to them, whether it's AI or a human, if they can tell, they can't say because it was, because your discussion about your scholarly works was generated by AI, or because your article was written by AI, if it's got the right citations and all that, I suppose they could question it. But generally, no. If the evidence is going to be evaluated on its terms, despite how the petition was assembled.
I'm going to put a link in the chat in terms of this AI use. Again, like it really does not take an AI expert to detect what's written by AI. I think we're all pretty adept at identifying AI slop. So USCIS officers are no different. So on a general basis, I would say that, yeah, if something is written by AI, it's very, very evident that it's written by AI. But Michael, I know that these sessions are always such that the more questions you ask, the more questions you can ask because all the answers lead to questions. But we're going to wrap up this session in a minute. If I can ask a question on behalf of everybody, even though different people have different motivations here, but what I can assess from talking to people is we keep oscillating between relief and panic. Like when we see these EB1 adjudication come through where there's pushback on panel merits, we get hopeful that, oh my gosh, maybe I have a shot. And then you see like this added scrutiny. And then like the visa ban happens. And as vulturistic as it sounds, it gives us hope that maybe we move forward. And then again, it's gloom and doom. So we keep oscillating between like hope and despair. So as we are working on our immigration cases in this climate, what's that one piece of advice you would give us? Realistic advice, how we navigate this journey more sanely.
Sure. No, and I can relate to the oscillation. I don't know if this is advice, but the thing I'd like you to know is, and I think if you take a breath and you check, good petitions are still being approved every day and in strong quantity, right? So If you are in a place where you have a good petition and don't wait to file it, you can't get approved until you file, and you can't get your green card until your number comes up. And there's a lot, as you all know better than me, there's a lot between day one and that final day, but you can't get there if you don't start. So every day, approvals are happening. Every day, people are getting responses, RFE responses turning into approvals. And every day, folks are learning what works and what doesn't work. So, the system is still producing at volume the benefits that you're seeking, right? And focusing on the twists and turns of any particular day right now will just drive you crazy. But until something massive happens to change the system totally, all these things are ingredients, but the system is still trucking forward. That's a mixed metaphor, but it's still working. So if you're seeking this out, make the best petition you can, take all the advice you can, consult who you need to consult, but don't hesitate, don't wait for the right time, because things are changing all the time, and you can't get your benefit even if it's 6 months or 18 months and then a visa bulletin wait of however long, unless you start.
Yep. Thank you so much, Michael. Once again, I've put your link in the chat, but if you do a LinkedIn search with Michael Valverde's name, you will get his profile. But Michael, thank you so much for being with us again. If you can leave a testimonial for Michael, you're going to get a link from TopMate, and I'll pass it over to Michael. Michael, thank you again, and thanks for folks who joined this session and learned a thing or two how USCIS works. There's hope at the end of the tunnel.
Always.
There's hope. Yeah, always hope. Thank you again, Michael. Thank
Okay,
you
thanks
again,
everyone.
everybody.
Have a great rest of your
Take
day.
care. Bye.
Hi, DT. I had a quick review before we ended this. Is she still here?